Or they could stand while I do this. Either way. Be safe. Thank you. Hi, everybody. I'm Andrew Fidel, and on behalf of the entire Moot Court Executive Board, it's my pleasure to welcome you to the 30th Annual John W. Davis Appellate Advocacy Competition Final Round here at Washington and Lee. This year's competition comprised a field noted both for their numbers and their excellence and quality of preparedness as appellate advocates. You are all truly in for a treat this evening. Before I introduce our distinguished panel, there are a few administrative thank yous that we'd like to make to people that have made this competition and everything we do on the Moot Court Board possible. Professor McDonnell, our faculty advisor, has advised us to make Moot Court here all it can be. So thank you, Professor McDonnell. Florentina Butler, who I'm not sure if she's here, but she's helped us with logistics and makes competitions, and especially when we host larger events like this, possible. Peter Jetton and Andy Briggs were instrumental to the taping, the technology concerns that are inevitable in pulling off a large competition like this one, and we even have a new timing system tonight that was thrown together today and should work really well, and it's people like that that make things like that possible. Our board's vice chair, Rebecca Clinton, does an incredible amount of behind-the-scenes work that makes everything we do go off without a hitch so far this year. Thank you, Rebecca. You've done an incredible job, and it would not be possible without you. Dean Smalla was unable to be here today, but as an appellate advocate of note himself, he put together a primer for appellate advocacy that no doubt contributed to the exceptional quality of the advocates you'll see tonight. And we'd also like to thank the Gardner family, who have been long supporters of the competition. And tonight they get to see their son argue in this court, and it's just proof that the apple does not fall far from that tree. So thank you. We'd also like to thank Professors Shaughnessy, Moliterno, and Fairfield, who graded the briefs and were forced to make incredibly difficult decisions in deciding among the nominees for Best Brief which ones indeed were the best and the second best. And they were faced with difficult decisions in making that, and again, it's a testament to their dedication to what we do. Also, Professors Massey, Professor Belmont, and Judge Forster judged the final round and narrowed the field from 8 to the 4 that you'll see tonight. And again, because of the quality, they were faced with exceptionally difficult decisions, and they put an incredible amount of time and effort into becoming facile with the problem and being able to make those decisions informedly. So thank you. Our judges tonight graciously offered their time and traveled far and wide to be here. Colonel Mark Johnson is the senior judge in the United States Army Court of Criminal Appeals. He's had a distinguished career in the Judge Advocate General Corps. Before he was a judge in the JAG Corps, he was a prosecutor in the 25th Infantry Division. He's been an instructor at the West Point Military Academy, deputy chief of the Government Appellate Division, professor and chair of the Judge Advocate General and Legal Center School in Charlottesville. He's a 1987 graduate of the University of Wyoming, a 1990 graduate of the University of Wyoming School of Law, and in 1999 he received his LLM from the Judge Advocate General School. He's admitted before the Supreme Court of Wyoming and various federal courts, including the United States Army Court of Criminal Appeals, the U.S. Court of Appeals for the Armed Forces, and the United States Supreme Court. His numerous awards include a Bronze Star and the Army Meritorious Service Medal, 2 oak leaf clusters. Colonel Johnson is happily married to his wife, Lisa Catherine Johnson. The Honorable Irene M. Keeley is a district judge for the United States District Court for the Northern District of West Virginia. Judge Keeley is from Clarksburg, West Virginia, which is John W. Davis, the competition's namesake's hometown. And we are fortunate to have a scholar in our presence on the life and times of John W. Davis. She's actually written a piece of information about his life, and if you talk to her later, she can tell you all about him. She was appointed to the district court by President George H.W. Bush in 1992, and she was chief judge of the Northern District of West Virginia from 2001 until 2008. She has also sat by designation on the Fourth Circuit Court of Appeals, and she practiced before she was appointed to the bench with the firm of Steptoe & Johnson in Clarksburg, West Virginia. She has an undergraduate degree from the College of Notre Dame in Maryland, a master's degree from West Virginia University, and her Juris Doctor from West Virginia University College of Law. She was associate editor of the Law Review at West Virginia, and near and dear to our hearts, she was a member of the Moot Court Board. She is a past chair of the Board of Advisors for West Virginia University, and as a judge, she was past chair of the National Conference of Federal Trial Judges. From 2005 until 2007, she was president of the Federal Judges Association and has won numerous awards, including the Director Community Leadership Award from the Federal Bureau of Investigations and the Daughter of the Year in 2003 for the West Virginia State Society. Judge Keeley is married to John Paul Keeley III and is the mother of 3 daughters. Chief Judge tonight is the Honorable J. Michael Ludig. He's the Executive Vice President of the Boeing Company and a former judge on the Fourth Circuit Court of Appeals, and was on President Bush's short list of potential candidates to be nominated for the Supreme Court of the United States. Judge Ludig was appointed by George Herbert Walker Bush in 1991 and served on the Fourth Circuit for 15 years. When he was appointed, he was the youngest federal appeals judge in the nation. Before he was appointed, he served as the Attorney General of the United States, Assistant Attorney General of the United States, and counsel to the Attorney General. He's assisted Justices Thomas and Souter in their preparation for hearings before the United States Senate and their confirmation hearings to the Supreme Court. And before his service at the Department of Justice, he was an associate at the law firm of Davis, Polk & Wardwell, the legacy firm of our competition's namesake, John W. Davis. Judge Ludig has also served as special assistant to the Chief Justice of the United States, assistant counsel in the Office of the White House under President Reagan, and notably as a judicial clerk to then Judge Scalia on the D.C. Circuit Court of Appeals and Chief Justice Warren Burger on the United States Supreme Court. He's a 1976 graduate of Washington & Lee undergrad, 1981 graduate of the University of Virginia School of Law, and Judge Ludig is joined today by his wife, Elizabeth. I understand that it is their wedding anniversary this weekend, so we're particularly honored to have them here, and they reside in Chicago with their 2 children. Thank you all for being here and making the effort to be here. The competition is named for John W. Davis of Clarksburg, West Virginia. He was an undergraduate alum of Washington & Lee and was known for his skills as an advocate and as an outstanding community servant. He was a law professor at Washington & Lee, a United States congressman, solicitor general, named partner of Davis, Polk & Wardwell, and he argued before the Supreme Court of the United States 139 times. In fact, he rejected an appointment to the Supreme Court to continue arguing before it. It is in his spirit of commitment to outstanding oral advocacy that the Davis competition is dedicated. Thank you to all who are here tonight. I'm now going to turn it over to Andrew Finicum, co-administrator with Benton Keatley of the Davis competition, and they are going to, Andrew will introduce the competition. Thank you.
Welcome again to the 30th Annual John W. Davis Competition. We're very thankful that you all came out to watch what we know will be a very strong competition. I am, Andrew Finicum, one of this year's competition administrators. 1 year ago, I sat where these finalists sit today, and I realize now, after dedicating time this semester and through part of the summer to this competition, the appreciation that we owe to many who made this opportunity possible. I would first like to thank Benton Keatley, my fellow administrator, who will later announce the best brief winners, for his dedication to the competition. While he volunteered me to introduce the competition to you tonight, it is his service and dedication that largely made this event possible. I would also like to thank all those who need no introduction to the competition and the subject matter of this competition, the participants who dedicated their valuable time to the competition. Their preparation and willingness to listen and apply the critiques along the way made it a true pleasure to serve in this position. Last year's competition included 69 participants, which was then one of the highest levels of participation in the history of the competition at the school. This year we had 88 participants. That unprecedented level of participation made narrowing the field all the more difficult. With 2 full rounds of student-judged oral advocates and a quarterfinal round that was also student-judged, the Moot Court Board dedicated over 130 judging hours to this competition. For that and their endless work behind the scenes, I thank the members of this year's Moot Court Executive Board. I would especially like to thank our chair, Andrew Fidel, for his tireless dedication that made it possible for us to present this outstanding bench that we're honored to present to you tonight. Moving on to the procedure that brought us to this point tonight. The competition began with 88 second and third year law students. These students prepared a written brief, written individually or in teams of 2, and they then each individually presented 2 sets of oral arguments, 1 round on brief, 1 round arguing for the side that they had written against. During each argument, the participants faced an admittedly hostile bench that was willing to interrupt them liberally at every turn. After 2 rounds, the field narrows from 88 to 16. In the quarterfinal round, it's down to 8. Then, in the semifinal round, the esteemed panel of faculty judges mentioned earlier narrowed the field of the finalists sitting before you. The participants' dedication, preparation, and skill made each of these decisions increasingly difficult, and we are more than pleased with the finalists prepared to argue before you tonight. Before we begin, I would like to introduce you to the facts and issues of tonight's case. The case of Doyle against Noorani centers on the Establishment Clause of the First Amendment to the United States Constitution. That clause reads, "Congress shall make no law respecting the establishment of religion." The United States Supreme Court granted cert on 2 issues. First, whether the presence of a Latin cross on a prominent rock in a national preserve violates the Establishment Clause of the First Amendment. Second, whether a congressional law that mandates an exchange of land upon which the cross sits to a private party violates the Establishment Clause, or instead solves any prior constitutional violation. Standing has been conceded in this case. The veterans of foreign wars erected the cross in 1934. Near the cross, the VFW erected a sign stating, quote, "The cross erected in memory of the dead of all wars." Another sign stated that the local branch of the VFW had erected the cross. Over the decades, that cross and the signs fell into a state of disrepair. The VFW repeatedly re-raised the cross, but failed to re-raise the signs, and those signs no longer exist. The cross was most recently replaced in 1998. In 2004, a friend of the respondent requested permission to build a Buddhist stupa next to the cross. The National Park Service refused to permit that stupa to be placed next to the cross and indicated that they were in the process of taking the cross down. The cross, however, was never taken down. Around that time, the ACLU threatened suit against the NPS, alleging that the cross was an Establishment Clause violation. When the NPS prepared to take down the cross, Congress intervened, passing several acts of legislation designating the cross as a war memorial, and eventually, and finally, mandating that the 1 acre surrounding the cross and the war memorial be transferred to the VFW in exchange for 5 acres of privately held land within the preserve. The respondent, R.F. Noorani, represented by the ACLU, sued the director of the Department of the Interior, among others, for an Establishment Clause violation. Noorani prevailed in both the lower courts, but the Court of Appeals was strongly divided over the issue. Petitioner Doyle contended below that the cross had a secular purpose as a war memorial, and that the land transfer solved any alleged constitutional violation. With that, we turn the evening over to our esteemed panel of judges and to the finalists who are prepared to zealously advocate these issues. Thank you.
All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
Please be seated.
We will now hear arguments in Crystal Doyle, Secretary of the Interior, in her official capacity against Arif Noorani. Is petitioner ready to proceed?
Yes, Your Honor. Petitioner is ready.
Is respondent ready to proceed?
Respondent is ready, Your Honor.
You may begin, petitioner. The court's ready.
Chief Justice, and may it please the Court, my name is Patrick Chamberlain, and I'm here today on behalf of the petitioners in this matter. At this time, I'd like to reserve 2 minutes for rebuttal. Your Honors, this case is about the government's efforts to honor our veterans. Specifically, it's about the steps Congress has taken to preserve a World War I memorial that sat upon federal land in some form for 75 years. Today, the petitioners will present 2 principal arguments in defense of this monument and the government's efforts to preserve it. First, petitioners will discuss why the continued presence of the Latin Cross War Memorial on Sunshine Rock does not constitute a violation of the Establishment Clause. And second, petitioners will discuss why the pending land transfer between the government and the veterans of foreign wars likewise poses no Establishment Clause concern. And for that reason, petitioners will ask this Court to reverse the decision of the Court of Appeals. The first issue this Court's faced with today is the presence of the cross atop Sunshine Rock and whether that constitutes an Establishment Clause violation. In answering this question, petitioners would point the Court to its test from Lemon against Kurtzman, as that test has been modified by Justice O'Connor's endorsement analysis from Lynch against Donnelly.
Is that really the standard you would prefer, that we decide the case under counsel? I wouldn't have thought so.
The petitioners do contend that the Lemon test remains the applicable Establishment Clause test for this under this Court's Establishment Clause jurisprudence, and as such, it does bind the Court in this case.
Well, I don't want you to hoist yourself on your own petard. We've repeatedly used other standards beyond Lemon, and certainly most recently. Why would you confine yourself to Lemon?
Well, this Court has indeed applied a variety of tests, and several justices have expressed some disapproval of the Lemon test. However, the most prominent test this Court has applied in looking at displays, religious displays on government land, is the Lemon test as colored by the endorsement test, which looks at the second prong of Lemon.
That's not what we did in Lynch against Donnelly, which is a case that I would think you need to distinguish to support your case.
Well, in Lynch, this Court recognized that Lemon does not apply in all cases, but then in fact went on to go through the first 2 prongs of the Lemon analysis, looking at the particulars in which that display appeared. And in this case, in the Lynch case, as well as in the Allegheny County against the ACLU case, this Court made clear that it's a very context-specific and fact-specific analysis. And 3 particular features stand out as prominent in this Court's jurisprudence when looking at a display, and those are the context and surroundings of the display, the location of the display, and the history.
How would you possibly distinguish Lynch in a way that would support your argument?
Well, Your Honor, as petitioners have noted, this is a fact-specific analysis, and each case is different. However, Lynch stands for the proposition in that case that a creche standing alone, or in that case, a creche that was surrounded by...
That was a Freudian slip, I suggest to you.
I was getting confused with the Allegheny County.
And a very damaging one, but go ahead.
In the Lynch case, Your Honor, this Court looked at a creche that was surrounded by other secular symbols. And indeed, that was one of the factors that this Court relied on in finding that particular creche didn't violate the Establishment Clause.
Quite unlike what you have here, right?
Indeed. The cross in this case does stand alone, and there's no symbols around it or sign to detract from its outright religiousness. However, the Latin cross in this country has come to stand for a second purpose, aside from just the standing for Christianity. In this country, the Latin cross has come to be used as a symbol to commemorate our fallen soldiers.
This is an argument that the government's been advancing repeatedly in this Court that I find very troubling, and that is that it comes in under the guise of the contextual argument and argues that purely religious symbols, in fact, are not religious at all. They have become secular by virtue of their surroundings. Isn't that an offensive argument for the government to make?
Well, I think that argument is in keeping with this Court's own cases. It looks at the religious symbols in the context in which they sit and not necessarily purely as the religious symbols themselves. And to this end, the cross in this case sits in the context of a vast desert preserve. It takes up just a few square feet in a 1.6 million acre federal preserve. And in addition, the location of the cross is far different from the location that this Court found troubling in the Allegheny County case. In that case, this Court noted that the creche at issue there sat in a location that a reasonable observer could do nothing but conclude that it's there with the government's approval.
Ipso facto here. If the cross is standing alone on federal land without anything surrounding it all contextually, how could it not possibly be viewed by an objective observer to accept Justice O'Connor's formulation as a religious symbol?
Well, the context in which the creche sat in the Allegheny County case, Your Honor, is very distinguishable from the context in which this cross sits. And while both do sit alone, a creche sitting atop a county courthouse staircase in a government building, as opposed to a cross sitting in a vast government preserve, it doesn't send the same message to a reasonable observer, because in the preserve, it'd be far more likely that a average person could construct a freestanding religious display without any government involvement.
So that's why I go back to Lynch and Allegheny. You've got to distinguish those cases, and they're distinguishable, but not in a way that supports your argument.
Well, I think, Your Honor, that petitioners believe that the Allegheny County case is distinguishable in the context of the place in which the display sits, and that was a huge emphasis of this court in that decision, is where that creche sat. And the petitioners believe that in this case, the cross, though it is sitting alone, is in a place where a reasonable observer could think that freestanding displays without government involvement would be far easier to put up. And looking at those contextual considerations that this court has taken into account in Lynch and Allegheny County, it would appear that this cross is highly distinguishable.
Well, what is the context that helps you?
The context here, Your Honor, is the fact that this cross takes up just a few square feet in a very vast desert preserve, a preserve that is distanced from any government centers of power, any government buildings. And a reasonable observer, even if knowing that the land is government land, would understand that in such a vast area, it'd be very easy for an individual to construct a freestanding display without any government involvement whatsoever.
So your argument is the objective observer seeing a single cross in a federal enclave is supposed to conclude that an innocent passerby placed it there? Is that the government's argument?
It's a portion of the government's argument, Your Honor. It's one of the contextual considerations this court should account for. But the reasonable observer also knows about the history of this display and the history of the form in which it sits under the reasonable observer analysis. So in this case, that means that the reasonable observer knows that this cross has stood since 1934 as a war memorial, has been put up by the VFW, and that the current version of the cross that was constructed in 1998 likewise was put up by a member of the VFW, showing that that war memorial purpose, that non-religious purpose for the cross is still alive and well.
Well, but now you're segueing over into Justice O'Connor's concurrence in Lynch, which, to my knowledge, is still just that, a concurrence, and that's not a position that helps you at all.
Well, a plurality of this court in the Allegheny County case looked at the endorsement test and applied it to that particular, the creche that was at issue in that case. So there has been a majority of justices on this court that have applied the endorsement tests in other environments. But what the government contends in this case is that
a majority of 5 justices?
A plurality in that case. It was 5 justices, yes. Did apply the endorsement test in that case.
A plurality of 5?
It was 4 and 1, Your Honor, excuse me. But it was 5 justices in that case that did apply that test and find that the particular creche in that case did violate the Establishment Clause.
I'm trying to understand this argument. Are you conceding that the cross is actually a government endorsement of religion?
Certainly not, Your Honor.
No?
Certainly not, and that's what these contextual considerations go to.
But does that argument really go that even if it is an endorsement, it's not to an impermissible degree because of the history and background and the fact that there might have been in part a secular purpose based on the fact that it was used as a war memorial? I'm trying to understand exactly where you're headed with this.
Well, there's distinct issues here, and the first is that the cross does have a secular purpose, and that secular purpose, as evidenced by its initial construction and everything since then, is that it serves a war memorial purpose. But that does sort of bleed into the endorsement analysis in that the reasonable observer is imputed with knowing that history. So that same knowledge of that same history comes into play when determining whether the cross is an impermissible endorsement of religion.
Well, does our jurisprudence forbid any endorsement of religion?
It forbids under the endorsement test, if a reasonable observer would view a display as a government endorsement of religion, under that test it would be a violation of the Establishment Clause, yes.
But you told me that you wanted Lemon to apply. I won't do it merely because you say it, but you are stuck with it for purposes of argument. But you don't want Lemon, do you? You want an endorsement test.
Well, with the government...
There's a difference between a primary effect test and an endorsement test, is there not?
Well, what the government contends is that the endorsement test has fused into the primary effect test, and circuit court decisions have interpreted it as such, and the government feels that's an appropriate interpretation because.
But we certainly have not.
Not to this time, Your Honor. But it's a related analysis, and the government believes that they do fit well together. And looking at the primary effect, it makes sense to look at it from the standpoint of a reasonable observer. The second issue that the court has to address today is the transfer, and whether the transfer itself constitutes a violation.
Well, let me ask you one more question on the
Sure.
reasonable observer. Would the reasonable observer be able to take their perception of the cross to the point where they could say, well, this is like other war memorials? I mean, you talked about other war memorials. Are there a lot of other war memorials that use the cross? Could that be an acceptable?
That's a common knowledge, a piece of common knowledge. And in fact, in Arlington National Cemetery, 2 Latin cross memorials exist: the Argonne Cross and the Canadian Cross of Sacrifice. And both of those are used to honor the sacrifice of our veterans. And indeed, there's several other examples outlined in the dissent in the Court of Appeals decision here that show that the Latin cross has been used for non-religious purposes in that sense. And that's a piece of knowledge that indeed a reasonable observer would know about because it's common knowledge. So turning to the.
If I could follow up one more
Sure.
time, would the fact that the plaque used to be there, if it were there again, make a difference to any part of your argument?
If the plaque is installed, it certainly would help the government's argument. The fact that it's not there is not troublesome in itself because the reasonable observer is given the knowledge of that cross's history, knows that it was originally constructed for that war memorial purpose. So the absence of that, it is a factor to be considered, but it's not dispositive in itself. And certainly installing it would go a long way to preventing any misperception of endorsement going forward. So the transfer itself at issue in this case does not violate the Establishment Clause for 2 reasons. And the first is that the transfer is not marked by any unusual circumstances that would justify viewing it as a sham. And the second is that the transfer itself survives this Court's Establishment Clause
So
tests.
if we were to find that the erection of the cross was an impermissible governmental endorsement of religion, does the transfer cure the violation of the First Amendment?
The government contends that it does, and it would point this court to the Seventh Circuit's decisions in Freedom from Religion Foundation against the City of Marshfield and Mercier against the Fraternal Order of Eagles. Those cases are not binding on this court, but they derive from this court's state action jurisprudence, and they look at whether a transfer or a transaction has unusual circumstances that suggest that really the government is going to be remaining as the owner even after the transfer, have that level of control associated with an owner. In this case, there's no unusual circumstances present that would justify viewing the transaction in that way. The level of government involvement going forward here is minimal in that all that's required of the government is that they install a replica plaque at the site of the cross, which will indeed reduce the risk of misperception of endorsement, and engage in some level of oversight just to ensure that the VFW doesn't transform this site into something other than a war memorial site, as the reversionary clause indicates.
But doesn't the reversionary interest make it a little different than some of the other transfers? And why is that okay here?
Well, the reversionary interest in itself is not enough to constitute ongoing state action. And the reversionary interest here, in fact, doesn't require that a cross be maintained on the site. All that it requires is that the VFW maintain the site as a war memorial. That's what the language indicates. So in itself, there's no requirement that a cross remain on the site.
You know, as you know, counsel, our courts never addressed this transfer question. But it seems to me, to follow up on Justice Keeley's question, that were we to decide that this violates Lemon and such that it establishes religion, then even if we adopted some form of the transfer doctrine from the circuit courts, unless we were to overrule Lemon, then that test that we would adopt would a fortiori say that because of the history and purpose of the legislative statute, it cannot save an unconstitutional establishment of religion.
My time is up. May I answer your question, Mary? If I understand your question correctly, the question is whether, even if the transfer is found to be acceptable, there's still an Establishment Clause violation by the cross remaining there, given the history of Congress's involvement in this cross.
Think of it as an analog to the secular purpose prong of Lemon. Whatever that transfer doctrine turns out to be in this court, unless we overturn Lemon, then the purpose behind the legislative action will be dispositive or not of whether there's a saving legislative act to an extant constitutional violation.
It's a combination of the purpose and the effect. The effect focus under that test will be whether the government is left with ownership-like
And
control.
I'm willing to give you that if you can get me out of the secular purpose prong.
Of the transfer itself?
Yes.
Well, the transfer itself serves a secular purpose of avoiding Establishment Clause litigation. And when the government is faced with an Establishment Clause dispute, it has the option of either A, removing the display, or B, transferring that land to a private party to divest itself of the message that display conveys. So here the government's choice to transfer the land to avoid litigation is a legitimate secular purpose. Thank you, Your Honor.
We understand. Thank you. Counsel?
Chief Justice, may it please the Court. My name is Kiyomi Bullock, and I represent the respondent in this matter. This Court has stated that the touchstone of Establishment Clause analysis is that of neutrality. The First Amendment mandates that even when honoring veterans, the government must remain neutral between different religions and between religion and non-religion. Accordingly, we would ask this Court today to affirm both the District and Circuit Court opinion for the following two reasons. First, the presence of the cross as part of the Texaco National Preserve is a violation of the Establishment Clause. And second, the transfer associated with that cross does not cure the Establishment Clause violation. Addressing then the presence of the cross. The cross is the preeminent symbol of Christianity. Respondent argues today that the appropriate test for this Court to apply will be the endorsement test, as seen by Justice O'Connor in Lynch against Donnelly. Under this test, the question then becomes, regardless of an actual or stated purpose, whether the effects of this monument are that a reasonable observer would perceive this as the government's endorsement of Christianity.
So you want us to apply the plurality decision in Justice O'Connor's opinion?
Yes, Your Honor.
Why would you not just argue straight up for Lemon?
Your Honor, Lemon is the endorsement test incorporates one of the prongs of the Lemon test.
Right, so you can have it all. You
Yes,
can
sir.
have a secular purpose, you can have an excessive entanglement, you can have a primary effect. It's a feast for you, but you can argue the case any way you want.
Respondent would argue that any test that this Court chooses applied today, the White Cross will fail because it goes to those fundamental tenets in the Establishment Clause.
It will
neutrality.
less likely offend the endorsement test than the Lemon test.
When you apply the endorsement test to the framework, you see that a reasonable observer will see this singular Latin cross standing on federal government property as an establishment of Christianity because any purpose, secular purpose, has then since fallen away.
Well, you don't have the secular purpose because now you're under the endorsement test, you said.
Yes, Your Honor. Primarily, respondent would ask this Court to view what the effects are. However, we do concede that there can be some secular purpose in that this has been dedicated as a Veterans Memorial. However, because the effects of the monument override that purpose and that the reasonable observer would see this as the endorsement of Christianity.
So far as we know, there's been one observer. I mean, where is this? This is out in the middle of nowhere where no one goes except apparently Mr. Nurani.
Your Honor.
And why he goes there, we don't know. But.
Your Honor, the cross is actually situated in a way that you will see it when you're driving through the main road that goes through the preserve. Also, if you look at the record indicates that every year people come to this site to worship on Easter, which is known as a predominant Christian holiday. So arguably, many people come, and many people come to practice religious services, which is one of the reasons a reasonable observer would see the primary effects of this monument as being overly religious.
Well, why wouldn't we look at this under the test that we enunciated in Van Orden?
Your Honor, Van Orden and McCreary argue for a very fact-specific contextual and history analysis, and that was applied to a passive monument. In the case that we're arguing today before this Court, we have a passive monument, but we also have congressional statutes that we have to determine the constitutionality of. We feel the appropriate test today would be that of the endorsement test. However, as we stated, any test that this Court should apply, the cross should fail because it violates the fundamental principles
But you've
of the
already
Establishment
conceded
Clause.
that there's a secular purpose for the cross on the land under Lemon, for Lemon purposes. Then you take the primary effect prong of Lemon, and you read that not in the untenable way, by the way, that we've interpreted, but instead in the much more elastic way of endorsement, this is going a long way toward undermining your case, just right here in front of you.
Your Honor, respondent would disagree. And we disagree because when you look at the history of what has happened to this cross, you see that the plaques themselves that originally designated the secular purpose haven't been placed with this cross for a number of years. They have fallen to the side, and it is only the private parties that have taken upon themselves to resurrect the cross.
But don't you feel the slippery slope that you're on? Once you've conceded that you want the endorsement test applied, and the so-called objective observer, which is meaningless, frankly, you bring in what Justice O'Connor did at some point nonsensically, all of the history, as if an objective observer knew all of that? Well, we all know that that's silly, but if that's the test you want, then the objective observer knows the history, and it has a secular purpose, as you've already conceded, and they know the history of the legislation. They know it's on private land now, and it's under an endorsement test. What's your argument that it's endorsement now?
Your Honor,
It's a secular purpose, and everyone knows, the reasonable observer knows, it's on private land.
Your Honor, the transfer has not yet been effectuated. As it stands before the court today, this cross still remains on federal land.
Okay, so is that really where you want to go? So we strike this down, and tomorrow the transfer goes through and the cross stays. Is that your point?
Your Honor, respondent would argue that even on private property, if this transfer goes through, this is still going to be a violation of the Establishment Clause. Before I move on to discussing
Well, what about deference to Congress, though? I mean, they want this memorial to remain. Shouldn't we then give that a lot of weight?
Your Honor, undoubtedly, this court should owe some deference to Congress. However, this needs to be seen in the remedial sphere that this has passed. This court in their jurisprudence has stated that when Congress purports to have a solution for a constitutional violation, the burden to prove the sufficiency of that actually rests on the government. I would direct this court to two cases.
So that's no deference at all.
Your Honor, that's a limited
Once
deference.
it gets in the courthouse here, there's no deference in that view, correct?
No, Your Honor, that's a limited amount of deference.
How would you characterize the deference? Is it 5%, 10%, and does it go to what? The effect prong or the endorsement?
Your Honor, respondent is unable to provide a numeric. This court has shown in its Establishment Clause jurisprudence that this really is a fact-specific analysis. So we would address this court to the facts of what lies in this land transfer, and looking at the facts, that is where this court can see the violation. Petitioner has asked that we apply two Seventh Circuit cases, that of Marshfield and Mercer. Under these cases, we're looking for unusual circumstances, or the court can simply look for evidence that the government has yet to relinquish their control over the monument. Respondent argues today that the government should lose for two reasons. The first is that the government retains important property interests and continues to exercise control over the monument. And the second is that the methods of effectuating the transfer violates the principles of neutrality.
So absent reversionary interest, then this cross is fine.
No, Your Honor. The reversionary interest is one aspect for this court to consider. The government has also written into the statute an easement on the property. The easement, if you see the context of 8121, specifically references that MPS must carry out all of its duties in the previous legislation, which was 8137. Part of this previous legislation mandates that MPS go onto the property and replace the cross and the plaque with taxpayers' money up to $10,000.
Then I assume from this intense fact-specific analysis, which I wouldn't have adopted were I you, that if this cross had appeared on the private property within the federal enclave, you would not be in a position of arguing its unconstitutionality, though it be visible to drivers by from the road who are going on the federal property.
Yes, Your Honor, that is a very different scenario than what's before us today. Not only do we have a land transfer of what used to be government property, but the government went as far to call this a national memorial. There are only 49 national memorials all throughout the United States, including some...
Congress did that.
Yes, Your Honor. Excuse my misspeak.
Yeah. I mean, the National Park Service didn't do that.
No, Your Honor, but NPS is mandated with the control and supervision of all national monuments. As long as this maintains its status as a national memorial, it becomes one of our iconic and most famous historical figures. We can look to the Lincoln Memorial, Mount Rushmore.
We can look to Father Marquette,
Yes, Your Honor.
who carries the cross.
Yes, Your Honor. However, that also can be differentiated from what's before us today because
How?
contextually there is more than just the cross there. No court of last resort has
You mean
ever...
because it's a human being carrying a cross, that makes a difference?
Yes, Your Honor.
You think that's the test? If the cross stands alone, as opposed to a priest carrying the cross, that there's a difference?
Your
And
Honor,
how we should look at it? Isn't that what the Father Marquette Monument is? Isn't it the statue of a Catholic priest carrying the Latin cross?
Your Honor, I'm not intimately aware with what that monument consists of. However, I can tell you that no court of last resort has ever upheld a single standing cross on its own, and that's because, as Justice Sudas said, there's no reasonable interpretation other than a religious meaning to that.
What would we do if we had, under your view of this, if we had public buildings that were in a cruciform architecture? Do we have to demolish those buildings?
No, Your Honor. This, again, is a context and...
So it's not the form of the cross. What is it then?
Your Honor, this court has never held, because one symbol has been used before and not violated the Establishment Clause, that it can be used again without violating the Establishment Clause. Undeniably, there are some national monuments or even other places in the government where the cross is used and doesn't violate the Establishment Clause. However, just because the court has found that in the past does not mean that the court today should find this cross standing alone in the preserve does not violate the Establishment Clause.
Justice Keeley understands that, but I assume, counsel, that we would have to clear all of the crosses from Arlington Cemetery, for instance, under your theory.
Absolutely not, Your Honor.
Why not?
If one is to visit Arlington Cemetery, they can walk around and see each of the headstones may in fact have other symbols on them. Some of them have Jewish stars, some of them have symbols of other faiths. In fact, when one applies for burial in the Arlington Cemetery, they can choose one of 49 different religious symbols or non-religious symbols that they would care to have.
The last time I was at Arlington Cemetery, when you look up across the hillside there, you see cross after cross after cross after cross. Under the arguments that you're making today, that certainly looks like an endorsement of religion.
Your Honor, respondent again would disagree with you, and in the context of the Arlington Monument, that there are more than one symbol present, we would say that it wouldn't in fact violate the Establishment Clause.
I'm sorry, I missed that point.
Your Honor, we do not think that finding this cross violates the Establishment Clause would necessitate that the government go through and take down every other cross, or that they would have to dismantle the Arlington Cemetery.
Well, I know, but it's incumbent upon you to explain analytically why that wouldn't follow.
Your Honor, because contextually, the Arlington Cemetery is different. It uses other symbols and allows people to make their own choice of what they would like to have on their headstone in that area.
Yes, but it allows the cross. So also on the land here, the choice has been given to the private individuals under the transfer.
Your Honor, this court can also choose to look to, if we would like, the method of effectuating this land transfer. How this land transfer came about was not the normal means of transferring federal land.
Well, now we're talking about the straight-up constitutional issue, not the Establishment Clause issue, not the transfer.
Yes, Your Honor, and I would direct this court's attention to that they did not follow the normal procedures. In fact, Congress, at the 11th hour, hidden in an appropriations bill, decided to put in this transfer.
But Congress does that all the time, not just in this issue. I mean, to hide something in an appropriations bill at the 11th hour, I would argue to you, is probably the manner of business for Congress, more usually than not.
And to the objective observer test now, it doesn't look religious at all. It just looks like the ordinary modus operandi of Congress. They probably didn't even know what was put in there.
And I bet they never read the bill.
Your Honor, we are not asking this court to rule on this issue alone to find Congress is putting this in appropriations bill as dispositive, but when you take it with the whole in that it was put into an appropriations bill, that there was no open bidding, that there was no open hearing, and that it was in fact transferred to the party that maintains an interest in keeping the cross erect, taken as a whole, you should be looking at Congress's...
Well, what about the government's argument? Let's say that only 2 or 3 congressmen actually saw the thing, went in. Their argument is that this is a war memorial, and the VFW maintained this before, they'll maintain it again, and they can take down the cross if they want. No requirement to have the cross. I mean, doesn't that get away from somehow offending other soldiers who have fought under a different religious guideline?
Your Honor, I see my time has expired. May I answer?
Go ahead.
Thank you. The VFW is not, in fact, free to take down the cross. If you look at the reversionary interest, the VFW is operating under a power of the NPS's subjective opinion. Furthermore, as long as it maintains its status as a national preserve, federal law prohibits the defacing or the destruction of a national monument. Because, in fact, the presence of the cross violates the Establishment Clause and the transfer associated with this cross hasn't cured the violation, we ask that this court find for Ark Noorani and affirm both the district and circuit court opinions.
Thank you, counsel. Petition for rebuttal.
The petitioner just had one point to raise in rebuttal in response to the respondent's arguments, and that's to the point that respondent made regarding the level of government involvement and control after the transfer. Here, the respondent places a great deal of emphasis on the fact that there's a quote, easement given to the government to enter upon the land. But the reality is that all this requires is that the government enter on the land on one occasion to install replica plaques that will reduce the risk of an impermissible sense of endorsement. And second, the second aspect of the government's involvement going forward is in the reversionary interest. And that reversionary interest does not require that the VFW maintain a cross on that site and will require only a very minimal level of government oversight to ensure that the VFW doesn't transform this site into something other than what it's always been, a war memorial. So for that reason, the level of ownership interest the government maintains is not that typically associated with owners.
Should we be troubled by the fact that Congress appropriated $10,000 for the erection of the cross, indeed with the plaque, as a replica of the original cross, which was a private act at the beginning? Does this now become government action when the government appropriates the funds and the National Park Service is going to actually erect the cross?
As I understand the 8137, the appropriations provision regarding this, as I understand it, the petitioner's contention is that it merely requires the installation of the plaques and the purchase of plaques, replicating the original.
I thought it was to reproduce the original cross. If not, I apologize.
Our understanding of it is that it requires only the plaques. And to that end, the petitioners believe that the government is engaging in a good faith effort to ensure that going forward, once this land is transferred, there won't be a sense of endorsement from the standpoint of people looking onto this cross.
Does the plaque or the memorial make any sense as Congress envisioned it without the cross?
I'm not sure I understand your question, Your Honor. I'm sorry.
If the VFW took down the cross, would that be contravening congressional intent, really? If you look at the language of the plaque, at least the prior plaque.
Well, Your Honor, may I answer your question? My time is up.
Please.
Well, Your Honor, the language of the plaque says that it was constructed as a war memorial purpose. And if the cross is absent, that site can still be used for a war memorial purpose, and that's all the reversionary interest requires. So for that reason, the petitioners urge this court to reverse the decision of the Court of Appeals. Thank you.
Thank you very much, counsel. Case is submitted.
All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States.
Be seated.
Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
We will now hear arguments in Crystal Doyle, Secretary of the Interior, in her official capacity against Arif Noorani. Petitioner, are you ready?
Yes, Your Honor, the petitioner is ready.
Respondents, you ready to proceed?
Yes, Your Honor, the respondent is ready.
Okay. Petitioner, go ahead. You may begin.
Mr. Chief Justice, and may it please the Court, at this point I'd like to respectfully request that 2 minutes of my time be set aside for rebuttal arguments.
Fine.
Thank you. May it please the Court, my name is Margaret Hannibal, and I represent the petitioner in this matter. This case involves congressional attempts to preserve a national war memorial erected 70 years ago by the veterans of foreign wars on federal parkland. Now, this case presents two main issues. The first is the constitutionality of that war memorial, which takes the shape of a Latin cross. The second is the constitutionality of a congressionally mandated land transfer, which transfers the land upon which the cross sits to the veterans of foreign wars. Now, this Court should rule in favor of the government for two main reasons. First, the continued presence of the war memorial, when considering its history and context, does not violate the Establishment Clause of the First Amendment, as it has a definite secular purpose. Second, even if this Court does find an Establishment Clause violation, the congressionally mandated land transfer cures that violation, as it is free from any unusual circumstances, extinguishes government control over the land, and ends any endorsement problems.
And what would the secular purpose be?
The secular purpose of this cross was enunciated by the VFW when it was built over 70 years ago to honor the dead of all wars. This purpose was once again reaffirmed when Congress, in their statutory scheme, designated the cross as a national memorial honoring the dead of foreign wars. And this purpose has been maintained for over 70 years every time the VFW rebuilt the cross. Also, when considering under Van Orden against Perry, the history and context of this cross, it's clear that the secular purpose has held for 70 years. Van Orden against Perry, this Court looked at the constitutionality of a Ten Commandments statue on Texas state grounds. And they held that because there was no government action and this was a passive display, the Lemon analysis was really inappropriate in that case. Now, if this Court is to apply Van Orden analysis, which the government urges that it should, examining the history and the context of the cross is the most important thing to do. And when we look at its history, it stood for over 70 years. It was built by a secular organization. It originally had a sign designating it as such. And in fact, when the cross was built, the land upon which it sat wasn't even in the federal parkland.
I wouldn't think so far that any of that would help you in the slightest. Do you have any more?
About the secular purpose
the secular
of the cross?
Purpose.
Yes. The cross, while its original purpose...
Just to make my point, because you seem perplexed, the fact that a cross has stood there for 70 years wouldn't seem to help you on its purpose.
Respectfully, Your Honor, the longevity of the cross reflects the fact that the veterans... While it's been there, it's been maintained by a secular organization. This is what I'm trying to get at.
I don't know that helps you either. A secular organization maintains a nativity scene on the courthouse steps. Does that render it a secular purpose?
Respectfully, Your Honor, there's a distinction between a nativity scene, which has a solely religious message, and a cross, which we as a society have come to recognize can serve a purpose of honoring our fallen dead, especially our soldiers. The Argonne Cross in Arlington National Cemetery memorializes the unknown soldier of unknown faith or creed. But we as a society realize that a cross standing there is an effective way to honor his sacrifice. We pin crosses on the uniforms of our soldiers who have given themselves in battle.
So the cross is a secular symbol?
Yeah, well, in this case, Your Honor, the cross, while being a religious symbol, does also have a strong secular purpose.
But there are a lot of other displays in Arlington. Isn't that correct?
Yes, Your Honor.
Wasn't that a factor in Van Orden as well? It wasn't the only display.
Yes, Your Honor. And while this court has never held a display standing alone to be constitutional, no one factor in this court's analysis has ever been dispositive. If anything, Establishment Clause jurisprudence urges this court to look at the entirety of the circumstances in the display of the cross. Here, the importance of the fact that it was built by a secular organization and maintained, and then Congress reaffirmed its secular purpose in this statutory scheme when it was designated as a national memorial to honor our fallen soldiers.
But you, too, have now tied your star to lemon for reasons that I still don't understand. But once you do that, let's say we accept your argument on secular purpose. That is, that it is a purely religious symbol, but in this context is secular, then pray tell, how do you get around the primary effect test?
Yes, Your Honor, and the effect test asks whether the effect of the display either advances or inhibits religion. And Justice O'Connor urges us to look to the reasonable observer who has knowledge of the entirety of the circumstances surrounding the cross.
But we've never held that. And you tell us that we should apply lemon.
Oh, if we should apply lemon?
Well, you told us to apply lemon.
Respectfully, Your Honor, I asked to apply the Van Orden analysis, analyzing the history and context of the cross. But if this court does choose to apply lemon, the cross still survives because it survives all three prongs. Now, the effect of this cross is a reasonable observer who knows the history of this cross will know that it was built by a secular organization, will know that it's been maintained by a secular organization to honor fallen soldiers, and will know the statutory scheme recently enacted by Congress, which reaffirms the secular purpose. Which brings me to the land transfer and the statutory scheme.
Well, I mean, you talk about the historical significance, but didn't the National Park Service decline to grant it any real historical significance?
Yes, Your Honor, and that's because the current iteration of this cross was built in 1998. Unfortunately, the original cross had fallen into a state of disrepair. The importance to note is the longevity of a cross being built on that site by a secular organization. The problem is the structure itself, the current one, lacks the historical importance, the PVC pipe cross lacks the historical importance that would require to be designated a historical site. However, the entirety of the longevity of the cross has a historical significance.
I don't see how you can win by arguing lemon. I think the government loses on lemon, and certainly the courts below felt the same way. Why shouldn't we just jettison our lemon test and come up with a new test? And if we would, what do you think it should be?
Your Honor, the government believes that Van Orden against Perry is the appropriate test in this case.
In this case or in all First Amendment Establishment Clause cases?
In this case in particular, because of the passive nature of the display. Lemon has drawn a lot of confusion and criticism from the lower courts. The government isn't prepared to say we're done with lemon, but just that it's not the appropriate analytical framework in which to work in this case because of the passive nature of the display. And because this court has never applied the lemon test to government inaction. They've never used it to say mere acquiescence of the government and having this display up would be the kind of government action required to even trigger lemon analysis. Which brings me to the government action in this case. This is where it gets a little tricky because when Congress enacted the statutory scheme, they mandated the transfer of land from the National Park Service to the Veterans of Foreign Wars. This effectively cured any potential Establishment Clause violations as it rid the government of control of the land. It also, the Seventh Circuit in March...
It didn't really do that since the statute itself mandates that the government spend $10,000 to erect a replica of the original cross and the original plaque.
Yes, Your Honor, and the $10,000 and the plaque actually reaffirm the government's secular purpose in doing so. The plaque will clear up any kind of visitor mistake because it will spell back out again that this cross was built in 1934 by the Veterans of Foreign Wars to honor our fallen soldiers. And once that plaque is placed, government control over the property ends. The VFW has been tasked with maintaining the cross, something that they've shown amazing dedication to for 70 years. There's nothing to lead this court to believe, nothing on the record that shows that the VFW won't continue to do that. If they do, if for some reason it's not being maintained as a war memorial, the reversionary clause in the land transfer guarantees the land can go back to the government. This reversionary clause reaffirms the secular purpose that Congress had in enacting the statutory scheme. Also, you'll notice that...
Could the VFW sell it to somebody else?
Could the VFW sell the land to somebody else?
Right.
Hypothetically. But that person would have to work with the easement, or not the easement, the reversionary clause interest. Obviously, they would have to continue maintaining the land as a war memorial. I think that gets much too into the realm of hypotheticals, Your Honor, that the VFW has shown for 70 years their dedication to this site and to this memorial. And to speculate into the future that they will no longer do this, that's what the reversionary interest is there to protect against.
But you're arguing that this land transfer takes the government, for all intents and purposes, out of that memorial. And that, for that reason, it's more secular in nature. So it's not absurd that the VFW does sell it to someone else. What would happen? What would be your position if they decided to put up something else? What if former, and of course this is a little bit astray, what if former World War I German prisoners who were relocated here bought it from the VFW and put up a statue of the Kaiser?
Well, Your Honor, in that case, I don't think it would be a war memorial anymore.
Wouldn't it? It would to them.
It wouldn't be the war memorial that Congress envisioned when they passed the statutory scheme. By designating the cross as the war memorial, Congress showed that they wanted to honor our fallen soldiers,
So
not the Kaiser. The cross itself is not essential. It would be easy to imagine that the VFW, for some reason, decides this cross doesn't work and put up a statue of a soldier or some either equally valid memorial in its place. It's up to the Secretary's discretion, his informed discretion, to decide whether or not the land is still being used as a memorial. If it ever fails this secular purpose, the land will go back to the government.
It seems to me that you've walked into the third prong of lemon on excessive entanglement in spades.
Yes, Your Honor. The third prong of lemon, the entanglement prong, asks about government entanglement with religion. Here, any entanglement that the government would have in looking in on the property would be with the VFW, a secular organization. This isn't the case of the government having to check in on a church group or anything like that, which, by the way, the government can do. Churches are tax exempt, and the government occasionally looks in on them to make sure that they're still conducting church activities. That's never been held as excessive entanglement. Here, we don't even reach that level because...
But this is only if one accepts the government's argument that the cross is purely secular, but that's untenable, and certainly your colleague to your right disagrees, and I think you're going to have an excessive entanglement from now on by some people who claim that the government is protecting the Christian religion through the cross.
Respectfully, Your Honor, that speculates an unconstitutional purpose onto Congress when they enacted this scheme. As a co-equal branch of government, this court does owe Congress and its mandated land transfer a degree of deference.
I'm separating out. I'll accept for purposes of this question that there's a secular purpose at the front end, and I'm positing an excessive entanglement on the back end. And how do you ever get around that?
Your Honor, because while the cross has a religious symbolism, the VFW won't have to interact with any kind of religious group. It doesn't ask if there's excessive entanglement with the symbol itself. It asks, is there excessive entanglement with religion? Your Honors, I see my time has expired. May I briefly conclude?
Yes, ma'am.
For the reasons we already discussed, the constitutionality of the cross and the problems that would be resolved by the congressionally mandated land transfer, the government respectfully requests that this court reverse the lower court's rulings and allow the congressionally mandated land transfer to go through.
Thank you very much. Counsel.
Mr. Chief Justice, and may it please the Court. Your Honors, my name is Mike Gardner, and I represent R.F. Noorani, the respondent in this matter. Your Honors, the continued presence of the Latin cross on Sunshine Rock violates the Establishment Clause of the First Amendment to the United States Constitution for 3 reasons. First, because it fails the Lemon test, which is the test that should govern this case. Second, because the government land transfer is an ineffective cure of that Establishment Clause violation and itself violates Lemon. Third, should this court accept the lower court concurrence's invitation to rework its Establishment Clause jurisprudence, the facts of this case should still create a violation because they run contrary to basic First Amendment Establishment Clause principles.
So because we're nearing the Halloween holiday, you want us to continue to respect the ghoul in the late-night horror movie?
Your Honors, Justice Scalia's colorful analogies aside, the test that petitioner would have you enforce, the Van Orden test, has never commanded a majority of this court. It has only commanded a plurality in one case.
But that's the same. That argument isn't much better than the argument. Well, we shouldn't look at the endorsement analysis of Justice O'Connor because it's only the concurring opinion. I know I've heard a very brilliant jurist argue that here this evening, but I mean everybody does look at it, don't they? So it's our most recent statement, and it completely ignores Lemon.
Your Honor, the most consistent analysis that this court has applied is Lemon, and it has been criticized for its recent inconsistency in the adoption of the endorsement test from Justice O'Connor's concurrence in Lynch. However,
isn't the truth of the matter we use Lemon where it works and we ignore it where it doesn't?
that is a general criticism of Lemon, but it is slightly overstated because the endorsement test is actually a subset of the Lemon analysis. If you look at Justice O'Connor's language in her concurrence, she stated that endorsement clarifies Lemon because under the first prong of Lemon, we look to whether the government has purposefully endorsed religion, and under the second prong of Lemon, we look to whether the primary effect, irrespective of the government's intent, gives the effect of endorsing religion from the perspective of a reasonable observer. So, Your Honor, if we can proceed to the Lemon analysis.
So you'll be comfortable if we apply the endorsement test purporting to apply Lemon?
Your Honor, it's Respondent's position that that is the intent of that was the intent of Justice O'Connor when she conceived of the endorsement test in her concurrence.
She only had one vote.
Yes, Your Honor, but the Court has since adopted that test on multiple occasions as a subset of Lemon.
Not as a substitute for the second prong of Lemon, counsel.
Your Honor, to the first prong of Lemon, then. And
I don't know why you would contend that anyway. That undermines your argument just like it did your colleagues.
Your Honor, irrespective of the relationship between Lemon and endorsement, the facts of this case create a violation of both, so we can examine them separately. We'll begin with Lemon. Under the first prong of Lemon, the government has to have a secular purpose for its action. And here, if we look at the analysis under McCreary against ACLU, the government action the secular purpose of the government's action cannot be a sham, nor can it be secondary to a primarily religious objective. Here, if you look at the facts of the case, this cross may have had an ostensibly secular birth, but since 1 year after its founding, there have been Easter sunrise services held at this cross every year, and the record does not indicate any evidence of individuals gathering for secular honoring of the war's dead.
Well, then you're in hot water already on the secular purpose prong. I mean, you just conceded that not only that it has a secular purpose, but that from its inception it was the secular purpose, and you're advancing here to an unheard of argument, to my knowledge, that the purpose for its origination can somehow change over time depending upon the use that it's given by the public.
Your Honor, the VFW claimed that this cross had a secular purpose when they installed it. Respondent does not contend that that secular purpose actually existed.
Yes, you did.
Your Honor,
we'll have the bailiff read the transcript back.
Apologies. When counsel said ostensibly, perhaps he chose his words poorly. The VFW claimed that it had a secular purpose. However, as Justice Souter has observed in his concurrence in Capital Square Review and Advisory Board against Spinet, a Latin cross standing alone can never be reasonably taken to have a secular purpose. Now, however, Respondent will not concede the secular purpose prong, but should this court find a legitimate primary secular purpose, it is not fatal to Respondent's case because the second prong of Lemon is also violated. And here, the government's action creates the effect of favoring religion in the eyes of...
Well, it's certainly not its primary effect, and that's the formulation of Lemon.
Your Honor, the primary effect of a Latin cross sitting alone atop a huge outcropping, a huge rock on one of the primary access points into this federal preserve would have the effect of the government preferring one religion over another religion and religion over non-religion.
Is that what goes on in Arlington Cemetery?
Your Honor, in Arlington Seminary, there is a large variety of symbols, and those who are allowed to be interred there, their families can actually choose which symbol are put on their tombstones, whether they are religious or non-religious. And so you have a wide variety of symbols, and this court has always found that with the existence of a wide variety of symbols in close proximity, the government is only acknowledging the role that religion plays in the lives of American citizens. And so
also here, but better, because it's the memorial for the slain.
Your Honor, the reasonable observer would have no way of knowing that. Petitioner states that the reasonable observer would know the legislative history.
Well, no, because that's the import of your having conceded the secular purpose. The reasonable observer would know that.
Your Honor, this court has in the past given quite a bit of knowledge to the reasonable observer. However, from an everyday citizen's perspective, if they come to visit the Federal Preserve, they come in on one of the main access roads, and they see a cross standing at one of the main points in the Federal Preserve.
How do they know that it's on federal land?
Because, Your Honor, this is 1.6 million acres of federal property, 90% of which is federally owned.
There are 1,800 private acres of privately owned acres, correct?
Indeed, Your Honor, out of 1.6 million. Additionally,
nevertheless, they're there.
They are there, absolutely. Additionally, however, the area around the base of the rock is a popular camping spot, which indicates that this is public property. And so this culmination of evidence would put forth to reasonable observers that the government has chosen to accept the Christian tradition.
Counsel, what if the government put up a sign that said end public land?
Your Honor, if it actually did end public land, then that case would be somewhat similar to the Seventh Circuit's case, Mercier against Fraternal Order of the Eagles, where there were 2 fences and 6 signs surrounding the Ten Commandments display in a public park. However, this is public property, and the government transfer has failed to cure that violation.
What if there was signage on the highway coming into the preserve that said the cross that you see is owned by the VFW?
Your Honors, even in as the Ninth Circuit has observed in separation from church and state against City of Eugene, even where there is a sign indicating that this cross serves as a memorial, the classification of a war memorial does not cure the Establishment Clause violation. And so what the government has tried to do is cure through a land transfer.
That was not the significance of Justice Keeley's question. She wasn't asking whether that would cure. She was talking about if you placed a sign, could the reasonable observer ever think that there's government involvement?
Your Honor, the reasonable observer would see that the government has allowed leeway for private individuals to erect a permanent sectarian symbol on federal property, which is in violation of 36 CFR Section 2.62a, which bans the installation of any private symbols on federal parklands.
Well, you can argue that after we reverse the Court of Appeals here on the Establishment Clause issue.
Your Honors, respectfully.
We limited the question presented to the constitutional one, not the Federal Register one.
Yes, Your Honor. Counsel's point was that the reasonable observer would see the leeway that the government has granted for one specific religion, which it did not grant for another one, the Buddhist stupa that applied to be installed. And now, to try and rid themselves of this entire problem, they have attempted a land transfer which doesn't actually transfer the land. Instead of simply giving title or doing a fair transfer, they have first, remember that this cross was about to be taken down, but Congress acted and the cross stayed in place. Then they designated it a national memorial, putting it in such company as the Washington Monument and Mount Rushmore. Then they enacted a land transfer, which has a reversionary clause, which keeps government control over the VFW and doesn't allow them to have the full ownership rights that traditional owners would, and under Section...
Where do you get that interpretation? As long as the VFW maintains the war memorial, Congress has nothing to say about it, and the federal government has nothing to say about it. It's only if it ceases to be a war memorial that the reversionary clause takes effect. Isn't that correct?
Your Honor,
in that way, Congress is probably protecting against an establishment of religion at its own hands.
Your Honor, in Hampton against City of Jacksonville and Eaton against Grubbs, the Fifth and Fourth Circuits, respectively, examined land transfers where the government sold land to private parties but retained a reversionary clause. And in both of those cases, the land transfers were invalidated because it said that the private parties could only act in the shadow of the reversionary clause, which, like this current one, required the private parties to maintain the property as it is. And so we have a current problem with the reversionary clause because the VFW doesn't know what the discretion of the Secretary will be. What it does know is that the status quo appears to work. And so that ensures that the cross will remain, and it removes the rights of the VFW to fully exercise their ownership. Further,
I'm not sure that we even have a case or controversy on the reversionary aspect of this until such time, as Justice Keeley says, it is or is not invoked. So if we say as a matter of constitutional law that the presence of the cross does not violate the Establishment Clause, then we would save to another day the question of the congressional action. Would we not?
Your Honor, if
you can bring it later, and when it's ripe, it wouldn't be ripe right now.
The reason there's a current issue is because the reversionary clause exercises a current impetus on the VFW to keep things as they are. And further, under 16 United States Code, sections 1 through 3, the United States is required to maintain all national parks and memorials and monuments. And so
you couldn't go into federal court and get an injunction today on the reversionary provision based upon the argument you just made, could you?
Your Honor.
Of course not.
Your Honor, Respondent argues that the culmination of all of these aspects of the land transfer, the immediate cessation of the attempt by the NPS to remove the cross, the designation as a national memorial, the method of transfer, which did not employ an open bid and went directly to the interested party, the reversionary clause, and the duty of the United States to maintain national memorials all create what is effectively a straw purchaser situation. The VFW does not have enough say in this deal to really exercise true ownership. However, Your Honors, should this Court decide that the current Establishment Clause jurisprudence leaves something to be desired and wishes to create a new set of guidelines or rules or tests, the facts of this case should still create a violation because they run contrary to the fundamental principle of the Establishment Clause, which this Court first stated in 1947 in Everson against Board of Education was the principle of neutrality. The government's...
That's certainly not what the clause itself says, is it?
No, Your Honor. However...
And we have not held in recent times that the government may not distinguish between religion and non-religion.
Respectfully, Your Honor, the first mention was in Everson against Board of Education. It has been mentioned again more recently in Lynch against Donnelly, Allegheny against ACLU, McCreary against ACLU. And so it does appear to be a touchstone of this Court's interpretation. And so when you look...
Is your best argument that we should look at the fact that although this is a passive display, it is only of the Latin cross? When you mention all these cases, you look at a distinguishing factor. We have always looked at what's the context. The government's argument here is the history and the context lead to a secular purpose. Not that the cross is secular, but that the purpose is secular. But the only symbol there is the cross. So that sort of puts you right into Van Orden. Even if we look there, can you distinguish the holding in Van Orden, the plurality holding in Van Orden, based on the fact that there's nothing else around this except the cross? It's just the cross.
Indeed, Your Honor. If you look at the history of the... I'm sorry, my time is up. May I briefly conclude? If you look at the history of the Supreme Court cases where this Court discusses symbols on public property, in only one case has it upheld a symbol standing in isolation, and that was Capitol Square Review and Advisory Board against Bennett. And the reason it was allowed to stand is because it was in a traditional public forum and it was seen as free speech. Your Honor, my time is up. For the foregoing reasons, respondent respectfully requests that you uphold the decisions of both lower courts. Thank you for
very
your
much,
time.
counsel. You have some time for rebuttal, counsel.
Your Honors, at this point, I'd like to rebut the respondent on two main points. First, with the issue of signage that Your Honors rightfully brought up. The respondent calls on Mercier and the 2 fences and 6 signs that the court looked at to decide that this land was clearly demarcated from the rest of the park. This park involved in the case there was wholly contiguous. It had no spaces of private land ownership within it at all, which is clearly distinguishable from the park in this case. The preserve is huge and expansive and involves private land and state-owned land within it. The reasonable observer, once this land is transferred to the VFW, could obviously speculate that this land is now privately owned.
Well, but you know, apparently I mistakenly ascribed lemon to you initially. You corrected me and you said you want an endorsement test under Justice O'Connor. So now you have the reasonable observer with all the imputed knowledge. So that reasonable observer knows prior to the transfer that this is government property for a religious purpose.
Your Honor, the reasonable observer also knows that this cross now stands on private property, where this court has always...
Pre-transfer, though, your DOA, right?
Respectfully, Your Honor.
On your own arguments, not mine, just on your own arguments.
Respectfully, Your Honor, even if that is the case, which the government doesn't concede, after the land transfer, these Establishment Clause violations are cured, which brings me to the second point I'd like to rebut of the respondent.
So you violate the Establishment Clause and correct it or cure it through congressional action?
Your Honor, in this case, the land transfer does cure any potential issues. Now, the respondent...
You don't want the objective observer test on the transfer, do you?
The objective observer will now know that this land is privately owned and private speech is protected.
What else will the objective observer know?
They'll know... Your Honor, I see my time is up. Can I go ahead and answer?
You have plenty of time for that question.
Can I conclude? May I conclude?
With your answer to the question.
Yes. Your Honor, the objective observer will also know about the circumstances surrounding the transfer. And the respondent urges this court to find that the government will still have control over the land. And this is plainly incorrect. In Marshfield, there was a reversionary interest that the land be maintained as a public park. The court found that this alone does not rise to the level where the court should strike down a statute as unconstitutional. Secondly, the VFW doesn't have to maintain this cross, as the respondent urged. They can choose to, or they can replace it with another form of war memorial. Finally, if the Secretary does invoke his discretion and does so wrongly, plainly that is a case for another day. As the dissent noted in the 14th Circuit case below this, the proper thing to do would be to enjoin that kind of behavior, not to strike down all these statutes as unconstitutional at this point. Thank you.
Thank you. This case is submitted. Court will now adjourn. Please be seated. The court is going to come down and greet counsel, after which we will deliver our conclusions from the bench.
Thank you very much. Thank you for coming.
Tough bench.
Thank you so much. It was a great argument.
Thank you.
You can sit. Hi, everybody. I'm Benton Keatley. I'm co-administrator of this year's Davis competition, and as you heard before, each of the competitors had to submit a brief either alone or with a partner to participate in the competition. This year, that meant 46 briefs. Andrew Finnickman and I graded each of them individually in order to determine the 5 best to then submit to our faculty panel. And 46 to 5 is not an easy cut to make. It took an awful lot of time, and we enjoyed reading the briefs, but it was a very difficult decision. Professor Shaughnessy, in submitting her results, indicated that it was a tough decision for the faculty panel as well, and that they considered it a privilege to read all of your briefs. So without further ado, this year's runner-up for Best Brief is Josh Shaw and Patrick Chamberlain. And the winner for Best Brief in the 2009 John W. Davis Appellate Advocacy Competition goes to Kiyomi Bullock and Marnie McCaleb. Congratulations.
Well, under the rules of the competition, it falls to the court to decide who the best oral advocate is and the runner-up for best oral advocate. Suffice it to say, it's harder to decide this than it would be to decide this case on the merits. And that's saying quite a bit. I think we decided that we're going to share with you some of the internal deliberations to this extent. We are generally familiar with some of the arguments that have been made in similar cases, let's just say, in the Supreme Court on or around this issue. The court wants to say to the participants and also to the audience, since we're not on the record, that your arguments tonight were every bit as good as, if not better than, the arguments that I make reference to, wherever those arguments were made, in the Supreme Court or otherwise. And that's not uncommon, but it's also something that you can be proud of. The amount of time and effort that you put into these cases is enormous, and you do a spectacular job as you did. That's not to say that the people who argue in front of the Supreme Court of the United States in real life don't put in the same amount of time and effort. It is to say that even in these younger years, when you put the time and effort in, you're their equal. So having told you that it's almost impossible to decide from among the four, and you can take our word for that, we did have to decide, and we finally concluded that the runner-up for Best Oral Advocate was Margaret Hannipol. And the Best Oral Advocate goes to Michael Gardner.